Good afternoon. This is Roger Guy of Chapter7Attorneys.com. I wanted to talk this afternoon about a topic matter that often comes up with clients, and that is the reaffirmation agreements and what they are. A reaffirmation agreement relates to secured property. That is, for example, property that the creditor can take back in case you don't pay them. For example, furniture, if you're still paying on furniture, or a vehicle, or a home, things of that nature. Could be a motorcycle, could be a boat, could be something like that. But a reaffirmation agreement within the context of bankruptcy law is really it's a new contract. And if you do have secured property that you are trying to keep in a bankruptcy case, you're going to have to sign a reaffirmation agreement with the creditor in order to be able to keep that. And the next step is, after it has been signed, is that agreement then is filed with the bankruptcy court. It's part of the permanent bankruptcy record of your bankruptcy case, and that contract actually survives the bankruptcy. And what that means is this: after you get your discharge, your Chapter 7 bankruptcy discharge, you cannot get out of that contract with that creditor. They can sue you, they can garnish you, they can collect, they can do all of that collection activities if you do not honor that contract after you have been discharged from your Chapter 7 bankruptcy. So you want to make sure that you can afford actually whatever that payment is going to be each month on that property. Otherwise you're going to be in a similar position that you were in prior to filing the bankruptcy. The other thing is too that the lawyer has to agree. Your bankruptcy lawyer has to agree and sign off on that reaffirmation agreement, or probably the court's not going to approve it. In fact, in the Raymond decision, what happened was the clients had wanted to reaffirm, they wanted to keep their vehicle, they wanted to continue to make payments on that vehicle after they got out of their bankruptcy. The problem was that the vehicle was worth about $5,000, and that the agreement that they were going to be signing called for them to make payments, or obligated them to make payments of about $8,000. And so in the Raymond case, the bankruptcy lawyer would not sign off on it. And the result was that the judge also would not approve it. Even though the Raymonds had signed it, even though the creditor had signed it, the fact that their attorney did not sign it was a reason that allowed the judge to not approve the agreement. And so this is a real simple process. Typically these agreements are approved by the court. Typically your lawyer will go ahead and sign off on the agreement, but every now and then you're going to run into an issue where the lawyer might not, and that's sort of the result. If you have any questions about reaffirmation agreements or any other bankruptcy questions in general, please call me. I'm available at 770-792-1000, and I have 11 metro meeting offices around town that we could meet at if you decide you need bankruptcy representation. Thank you for your time, and I hope that you found this video to be useful.